to the answer?
Oh, well, I did send it to them. So I sent them all
Send it to who?
to Jill. And
Jill Bauer at Legal Aid. Your
Okay. Augusta Woods versus Eric Roden. That matter's dismissed on plaintiff's motion. And Beal Properties versus Melissa Daly. And some more. Yes, Melissa Daly, Carla Hardman, and Cindy Hardman. Okay.
Daniel Landman for the plaintiff, Your Honor. I received within the last 48 hours I ostensibly from Ms. Daly, but drafted by and submitted by Legal Aid, who claims to be assisting Ms. Daly in this case, a jury demand and an answer. The answer referenced some attachments that were not provided. And I have an issue with these documents that were very clearly drafted by Legal Aid rather than by Ms. Daly. I don't know if the nature of the quote unquote assistance that's going to be provided is full discovery, whether Legal Aid is going to jump in 48 hours before trial. I think that there's some ethical issue with ghostwriting and claiming to only be assisting. That being said, what has been filed with the court is an answer and a jury demand. That is where we are. The termination case, it's not a non-payment case. I would request that as this case plays out, that an escrow order be entered requiring payment of monthly rent into escrow with the court.
Section 8 pays my rent, all of it.
So you have Section 8 and year 0?
Yes. And Legal Aid, it helped me file the answer, and they're still investigating.
Okay, but you're right, I understand. And here, well, right, but
They told me.
let me ask you, go ahead, what did?
Okay, they said they're still investigating the case, and there are 2 reasons that Stewart is evicting me, and I have proof that the reasons is neither of the reasons is right. The first is that my dog is unauthorized, but I have written proof that Stewart got a letter, or Chandler and Stewart got a letter from my doctor saying my dog is an emotional support animal. So this proves that they have known about the dog, and Chandler okayed it. The second is that I had box belongings in the front room and in my room, but this is because the basement floods all the time, so I had to move my things upstairs. Have asked to fix the flooding, and they have not. I have videos of the water leaking through the walls.
Okay, so ma'am, let me ask you this. Is that contained in the answer here? What you just told me?
I think so, yes.
Not in those exact words, Your Honor, but the answer is yes.
Okay.
Although the answer also purported to claim that there was some kind of written documentation of either the emotional support animal or the approval of it. And there were allegedly attachments, and I did not receive any of those attachments. I don't know if the court did.
Ma'am, do you have the attachments?
I have the letter right here in my phone
from Stewart Beal?
What do you mean?
Well, what are you trying to show me?
This is the letter from my doctor stating that I needed that she is my emotional support dog that I need.
Okay, but I thought you said there was some communication from Stewart Beal.
Chandler, I have text messages because
okay,
I guess they forgot, and Rich, the maintenance man, told him I had a dog.
Okay. I hear you. I'm just saying.
Yeah, I have text messages.
So yeah, but they're not none of that's attached to the answer.
Oh, well, I did send it to them. So I sent them all.
Send it to who?
To Jill.
Jill Bauer at Legal Aid. Your
Okay. So, ma'am, here's going to be the problem. If legal services, they're going to answer this, Okay, it to the extent that they can. And if I set it for jury, are you gonna be ready to have a
Yes,
jury?
yes.
You're gonna do it yourself?
Oh, no, I will have legal representation.
Who?
They are giving me legal representation. Okay,
But are they?
yes.
Did they
They're
say
giving me-
that?
Yes, I was on the phone yesterday with Jill. There's another lawyer that wants to take my case and her, either one, but I'm gonna have legal representation. Derek Johnson, I think is his name, or
Who?
I think his name is Derek Johnson,
Okay, all right.
or Jill Bowers. One of the two will have it.
Okay, so here's what's gonna happen, because this thing isn't gonna go out 2 months to my next jury selection, so it may be that this gets selected in June,
Okay.
and they need to know that. So
Okay.
that if they're gonna represent you and all of this is gonna happen, then,
Yeah, she told me last night, I will for sure have representation.
all right, then tell them I'm moving this out to the 31st next Friday at 3 p.m. and that if you're gonna be represented, they need to be here. Fair enough?
Fair enough.
And
In person, right?
in person. Yep. I want them here.
Thank
And
you.
I'll indicate for the record, Your Honor, that the two communications that we received from legal aid, the jury demand came from Alex Henry. The answer came from Jill Bauer.
Yes, because Alex was helping, because there wasn't enough time, because they only do the walk-ins Tuesdays and Thursdays. So I had to go Tuesday and I had to be here Friday, so there wasn't.
No, I understand, but
Yeah.
I think the point is this. There's been a jury requested. There's a legal document that's been filed. You come here and there's no attorney. And
That's what I told him. I said, I really would feel comfortable if you would come.
and so would the court. But I'm gonna give a week, tell them that they need to be here.
Okay,
All right?
all right.
Thank you.
Thank you, Your Honor. That covers everything.
That's
Once
it.
again, thank you for consideration and have
Not a
good
problem,
weekend.
not a problem. Drive safely. Court does call the case, Arbor Meadows versus Hector Molina.
Good morning, Your Honor. Laura Kruby on behalf of plaintiff.
They are not checked in. Hector Molina, no response. You paid for the second service. If you'd raise your right hand to be sworn, you may proceed. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
Your Honor, plaintiff moves for a default judgment in this matter for possession only. We've got, I'm just making sure it's possession only. We've got rent owed in the amount of $1,918.33. Court costs of $175. Total is $2,093.33. Your Honor, we are
At 293.
yes,
Okay,
$293
go ahead.
and 33 cents with a requested writ date, Your Honor, of June 3rd.
Judgment to the plaintiff, that's by default for possession. Redemption amount is in the amount requested. Writ issue in 10 days.
Thank you, Your Honor.
Arbor Meadows versus Pedro Quijada.
For the record, Your Honor, Laura Kruby on behalf of plaintiff.
Pedro Quijada. No response. You may proceed.
Your Honor, plaintiff is requesting a default judgment in this matter for possession only, rent owed in the amount
Sticker.
of. What is it?
Go ahead. No, it's something here, not you.
Oh.
Go ahead, counsel.
Rent owed is $1,049.94. Court cost is $175. Total is $1,224.94. And same writ date, Your Honor, June 3rd.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested with a writ issued in 10 days. Then I've got Arbor Meadows versus Carmona, Arbor Meadows versus Hernandez Salazar, Arbor Meadows versus Thomas Miller. Those matters are dismissed on plaintiff's motion without prejudice.
Thank you, Your Honor.
Thank you. Is that it for you or you got more?
I've got two more.
These other two, gotcha. Augusta Woods versus Rhonda Tucker and Staven Tucker.
Laura Kruby, Your Honor, on behalf of plaintiff.
Rhonda Tucker's here. Ms. Tucker, can you unmute? State your name.
Yes, Rhonda Tucker.
All right.
Can you hear me?
And what's plaintiff's claim in this case, including cost?
Your Honor, this is actually termination of tenancy.
Oh, it's a termination. I'm sorry.
That's okay.
All right. Ms. Tucker, what is your position on the termination of tenancy?
I well, I disagree with it.
Okay. Are you going to get representation, or how are you planning on proceeding on this?
I mean, my understanding is if we can come to an agreement on dismissal today, then that would be the end of it. Otherwise, then we would set another date, and yeah, then I would be obtaining representation.
Well, when you say dismissal, you're talking some conditional dismissal with conditions?
I mean, I'm not sure. I was just listening to what was being said. Maybe I misunderstood how it was being,
Okay, what would you like to do? I guess is my question.
You mean in regards to, okay. What I would like to do is stay in my home is what I would like to do. That's what my husband and I would like to do. So I guess if we have to go to trial to do that and I'll obtain a representation in order to try and secure that, then that's what we'll do.
All right, then what we'll do is I'll adjourn this out 1 week to allow you an opportunity to speak with an attorney.
Okay.
Okay.
All right. So next Friday.
So I'll adjourn it to May 31st, 2024 at 3 p.m. You'll need to file an answer
Okay.
prior to that date to the claims.
Okay.
So
Your
you'll
Honor,
need to
this
file,
person-
you'll need to file that by the 30th.
All right.
Okay. And what I will do is I will indicate escrow at this point is reserved.
And what does that mean?
That means that plaintiff, I would imagine, has not been accepting rent.
Yes, they have.
Well, you're paid through what date?
May 31st.
Counsel, is that correct?
I have no knowledge of that, Your Honor. Ms. Tucker, when did you make that payment?
The 1st of May.
I believe, Your Honor, it was during the period of the 30-day notice that was sent out, but we don't accept payments after the 30-day expires.
Well, no, I know, but we're going to have a problem. Because counsel, if they accepted rent after April 15th, which is the expiration of the notice in this case, then we got a park forest problem.
Understood, Your Honor. May I ask Ms. Tucker if this is an auto pay, or did you go in there personally and give
No,
them-
I went in there. I went in there personally.
Okay.
Like I do. I don't have anything set up on auto pay. Never do.
Your Honor, what I can do is if my client isn't here, but I can confirm today, and if they did accept payment for the month of May, I can ask them to return it to her and she can escrow it with the court.
Well, I don't think that will work. Certainly that could be your position, but if they accepted rent after, well, and there's going to be even more of a problem because if they accepted rent in April, we're going to have a problem. And if they accepted it,
Which they
certainly
did.
in May, we're going to have a problem. Well, what I'll do, counsel, is, ma'am, you need to, how did you pay your rent in April and May?
I pay it online through their,
Okay.
yeah.
So you have proof of the payment of rent?
Yes.
Okay, so you need to provide that to the court by the 30th also, okay?
Okay.
Because that may take care of certain issues or may take care of the case, quite frankly, but we'll see. All right, I'll adjourn it out to the 31st. I'll expect to see an answer as well as those things, and then we'll go from there. Okay,
Yeah,
Yes,
is
sir.
this, I apologize, is this in person?
via Zoom. We can do it Zoom.
Okay.
All right, thank you.
Thank you, Your Honor.
Court calls the case of Kurt Gassel versus Artie Dracos.
Good morning, Your Honor.
And
Jay
I'm sorry.
McCurdy.
And also, is it Gadadari?
Yep.
And
Good morning,
Jeannie
Judge.
Draco. Go ahead.
Good morning, Your Honor. Jay McCurdy on behalf of the plaintiff.
All
Good morning,
right.
this is
And who?
Dadadari.
All right, very good. All right. Are the other two defendants present?
I have no idea.
They are not checked in. So I only have defendant 2. So 1 and 3 are not here. All right. All right. From the plaintiff, where are we on this case?
I received an email yesterday in the evening, late, like towards midnight, that the plaintiff had moved out. We haven't been able to confirm that, or the defendant had moved out. I haven't been able to confirm that this morning. Maybe if I could speak to God, that we can come to a resolution on the case.
Yeah. Good morning, you guys. So I just wanted to inform you, Judge and Jay. So after signing the agreement, and prior to moving in, I decided not to move in for personal reasons. Since I've never resided at there was no reason to evict me. I've only agreed to a 12-month contract since I've not lived there. I should have no liability for the holdover period. The Dracos family have solely decided without my knowledge or consent to continue to live there past a contractual agreement. I don't have any possession and I have no right to enter the property. I don't have keys or possession at the property. The agreement.
All right. Hold on.
Yeah, I just kind of made a list of
Let me
things.
catch up. So had you ever resided at the property?
Never.
Okay. And
Never.
but if I heard you correctly, you signed a leasing agreement but never moved in.
Correct. I had, for personal
Okay.
reasons, I had decided not to move in.
Gotcha. Okay. So do you guys know who's residing in the property?
The Dracos family, as far as my knowledge.
Got it. So defendant 1 and defendant 3 may have been residing there, but you did not. Okay.
I did not.
All right. Well, counsel, what do you want to do on this? Because you've only asked for possession. This defendant 2,
Your Honor,
says
we
she
checked the
never
box.
had possession. Pardon?
We checked the box for money judgment. And we were actually a little surprised when the court, when we filed the case and they didn't accept the, let me see, I have that complaint that I filed. We did check the supplemental complaint for the money judgment.
I don't have payment for any money judgment in the filing fee.
In the filing fee, correct. And we were surprised when the court wouldn't accept it. She told us it was 55. My legal assistant tried to tell her it was more than 55. It should have been about 150. And she only accepted 55 and told us that's what. But if you look at the paperwork.
What do you mean she only accepted?
Your Honor, I sent my legal assistant down there with payment to file the case. And he's well aware that it would have been $150 or so to file this case. But the clerk at the 14A4 insisted it was 55 and wouldn't.
Dear God. Okay. Okay. Well, I just can't do everybody's job. Well, here's part of Does your client acknowledge that Ms. Dari was not residing there, or
Correct. Yeah, we acknowledge that.
he knows that?
Is the, and no offense to Miss Dari, it seems to be Miss Dari is the only collectible party on this. And she's a like signer or co-signer on the lease, which is why she's named.
Jay, Your Honor, so as far as my knowledge, and again, I'm as green as possible and I'm representing myself. The agreement did not have did not reference a notification. So when I decided not to move in, the Draco's family said they'll take full responsibility for that 12-month period that we signed. So,
Well, okay, let me back up a second. The lease, the original lease, or the lease, the only lease, I guess, that has expired.
yes, Your Honor.
Okay, so had there been a, well, let me look at your complaint, that how much was monthly rent
$3,800.
a month?
Correct.
So the only, just, and correct me if I'm wrong, the only rent claimed, if I'm looking at your complaint here, is rent after the expiration of the lease,
Correct, Your Honor.
which Ms. Dari, although not even residing there, her liability would have ended at the end of the lease.
Wouldn't she be considered jointly and severally liable for the holdover period?
No.
That's going to be a question because she, I mean, outside of never moving in, I mean, let's forget about that for a moment. If she had never, if she signs a contract, she fulfills that contract in essence because everything is paid. She's not there. She moves. I don't have a copy of the contract, but I don't know that it's joint and several once the holdover period because she's vacated. There are other people that are in the premises. Now,
Well,
there may
she
be a
didn't
theory
vacate,
upon
Your
which
Honor.
she might. Pardon?
She never vacated, Your Honor. She never moved in. I believe that they used.
No, I know.
Yeah, I
That
believe
makes it even.
My understanding was her like credit was used to justify their like ability to move in.
And that's incorrect. I was actually planning on moving because due to personal reasons, I'm going through, again, I'm not putting my information out there, my personal.
No,
I'm going,
you don't have to.
I don't have to.
It really doesn't.
I'm going through a
It
personal.
really doesn't. It may not matter for the purposes of the case. It might, as to your reasons, but at this juncture, I don't think it does. So we got to correct a couple of things in here. First of all, what would, I don't understand the 99 on this. What do you? I have under service, Washington County Sheriff's Department, it says plus 99.
That might have been service for all three individuals.
Yeah,
That must have been 33 at each. Okay.
it's 28 for two of them and then 43 for another.
Got it. Okay, fine. But what has to be corrected is the money judgment.
I can drop off a check for the difference, Your Honor.
No, I know, and I guess for educational purposes, they don't know who they spoke to.
I
do
can
they?
find out. Ethan probably wrote it down. He's very, I mean,
Okay. All right, why don't you do this? I'll indicate defendant to pay for the money judgment filing fee. Whatever that is. So get a check there. And we'll deal with that. And then I'll adjourn this out to the 31st, 2024 at 12 noon. Okay, now ma'am, are you intending on being represented or?
No, I'm representing myself.
All right, very good. All right, plaintiff is also to, I don't have a copy of the lease that was there. I realize
Yep.
it's a holdover situation, but with Miss Dari's particular position in this, I'm gonna need a copy of the lease that was applicable to the premises. So I'll indicate plaintiff to file a copy of the lease.
Your Honor, that was also dropped off, but I will drop that off as well.
Was it?
Yes, sir. Yes, Your Honor. The full packet.
Yeah, I just. Oh, I believe you. I just.
14A4 is out
I
there.
just get me a name, please, if they've got it, because this is. I believe you did what you say you did, and I don't have anything. So, all right. And if you, I'll tell you what, counsel, why don't you send a copy of the lease directly to us?
Okay.
All right.
Thank you,
And
Your
that
Honor.
way we'll have it.
Do they know if it was filed immediately when they filed? Like, did they stay and watch the clerk file it?
I don't care.
I was gonna get you a name if that's.
Oh, you were gonna give me a name?
Yeah.
Okay, no, we'll figure it out. We'll get that corrected. He's gonna pay the filing fee and then he's gonna send, if you can send that directly to Ann at my office.
14A1.
He'll put an email, she'll put an email in the chat for you.
Thank you.
All right. Okay. Ms. Dari, any questions you have, ma'am?
Just the Zoom ID, is it the same one for the 5:31 noon?
On the 31st?
Yes.
Yes.
Okay, thank you so much.
All righty, thank you.
And Ms. Star,
Have
if
a
you
great
want
day,
to call
guys.
my office at any point, feel free.
I'm sorry?
All right.
If you ever want to call my office, that's fine. We can discuss this further.
Okay. Thank you so much, Jay. Have a
Alrighty,
great day.
thank you.
Bye, guys.
Barnes and Barnes versus Justin Liskey.
Ellis Friedman for the plaintiff, Your Honor.
Justin Liskey.
All right. Mr. Let me see, is it on both of them? Just so that you know, I don't have on your cases for whatever reason, Mr. Friedman, proofs of service, but I don't know that it's going to matter on one of them, but we don't have them. Well, we might, and they're just not here. I don't know. All right. Anyway, what's the claim in this case, Mr. Friedman?
Total 2672.
2672.
Yes.
All right. And sir, what do you have to say about that, Mr. Liskey?
I'll be making a $1,000 payment tomorrow.
Okay, you're gonna pay $1,000 the 25th. Okay, and then you got about 1672 balance then. How are you gonna get that paid?
I should have another 1,000 the week after, and then I lost my job. And I had,
1,000. Hang on a second.
yep.
You're gonna pay 1,000 on the 25th, and then what, 1,000 on the 1st?
Yeah.
Okay, but your rent's gonna click in. So how
Right.
much is monthly? How much is monthly rent?
$9.95.
Okay, let's do it this way. I'll adjourn the matter out 1 week to the 31st. You pay that 1,000, but understand something, sir, if it's at noon.
No, that's gonna be at 3.
At 3, this is the 31st at 3 p.m.
Okay.
If the 1,000 is not paid, or at least the 1,000 is not paid, I'll just be granting them a judgment because you're gonna get that paid. Otherwise, we'll see how we can get this structured so that you can get this paid and get yourself back on track.
Okay.
All right. Okay. Thank you. 31st at 3 o'clock. Glen Oaks Cooperative versus Kelly Andrews.
Your Honor, we're going to be sending in a conditional order of dismissal on that.
I'm sorry? I do.
Excuse me.
Yes, sir. I have it in front of me. I'm sorry.
Yeah, hard time. I'm going to do a COD on that.
This case is conditionally dismissed and I've signed off on that.
Thank you.
Are they here?
Yes,
They did not check in. Oh. Pardon?
yes, here.
Oh, there you are. Okay. Hold on a second. What's your name?
Dane Jones.
Okay. Is Kelly Andrews here? They're not, so I've taken care of that. All right. Thank you. Court calls the case Glen Oaks Cooperative versus Dana Jones.
Your Honor, he's basically all we've got is cost, so we're going to dismiss.
All right. Sir, you have, is your name Dana or Damon?
It actually is Dane Jones, Dane. They got me as Dana. Yeah.
I got 3 names for you. I just, it is
That's
too early on a
ridiculous.
Friday for me to be dealing with this. All
That's
right.
quite a coincidence,
But
Your Honor,
you're,
'cause I'm the
you're
third.
at Glen Oaks.
Yeah.
Okay, and that's a 1429, correct?
1429, correct. Yes.
Okay, that case is dismissed, whoever you are. Okay.
Okay. All right.
All right, thank
Y'all have a
you.
blessed day. Thank you.
You do the same.
All right.
Is that it for Mr. Friedman?
Yes.
Okay. Sharon Bell versus Melissa Mason. Miss Bell, you need to unmute.
Unbelievable. Can you hear me?
All right.
Yeah.
Yes, now I hear you.
Oh my God. Good.
It's okay. What's your name?
My name is Sharon Bell. I'm the plaintiff.
Okay. Yes. And is Mason here? They are not. Okay, so I have one problem with your case, ma'am, and that
Okay.
is I don't have a proof of service.
A proof of service meaning the summons didn't go through for her?
Yeah, it doesn't, I don't know, because I don't have anything to indicate that she was served with the paperwork.
This is the problem. She abandoned the house and her children and is,
Okay, no, well, I don't know that, but I now know that. But if they're not
Yep.
there, then there at least has to be some type of service like posting on the premises, whatever. But
I did give her a notice to quit and I did have a witness.
no, the notice to quit is not my problem. My
Okay,
problem is that the complaint
Can't
that you
find her.
filed, there has to be a proof of service filed. So there would have been a mailing that went out, but there has to be, somebody has to serve that complaint.
okay. The situation is the person is not in the home.
I know.
The
told me that.
grandparents are in the home. They've communicated with her, but there's no proof, like you said. So what do we do? She just vaporizes and,
I don't have proof of service or attempted service.
meaning that you don't have proof that she's been served,
Correct.
right? And
So I can't proceed.
can I do this? Do I talk to the sheriff to tell him where I think?
Yes, you can talk
maybe?
to the sheriff department about service on her.
Okay,
I'll adjourn it out a week for you to try to get that accomplished.
okay, thank you.
All right.
Yep,
May 31st, 2024 at 12 noon. Okay?
sounds good.
All right, thank you.
All right.
Court calls the case of Arbor One versus Derek Graham.
Good morning, Your Honor. Cheryl Welkoff on behalf of the plaintiffs.
Derek Graham has not checked in. You paid for additional service. Would you like to proceed?
I would.
Do you
Your Honor.
solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor. Your Honor,
Go ahead.
plaintiffs for a default judgment. This is an action for possession due to lease expiration. The notice was sent pursuant to MCL 554.1341. And we are asking for a judgment of possession only with the writ date of June 3rd, 2024.
Judgment to the plaintiff by default. No redemption amount. Writ to issue 10 days.
Thank you, Your
Thank
Honor. I have
you.
one case at noon and I'm sending in a dismissal right now.
Oh,
So
okay.
do you want me to
Well,
log back in at noon for that?
No. Well, we'll take care of it.
All right, thank you so much. Have a wonderful weekend.
You do the same.
Thank you.
Your Honor, the next case requires a Spanish interpreter. May I swear her in?
Court does call the case of Orchard Grove versus Jose Cerda, is it Aguina, and Jose Cerda Contreras.
Ahora
Alex
digo, bueno,
Lubianski, P77
Hold it.
121.
The counsel.
My apologies.
Thank you. Go ahead, Madam Interpreter.
ahora me toca decir buenos días. El tribunal llama el caso de Orchard Glow en contra de los acusados José Cerida Aguirre y José Serrano Contreras.
All right, counsel, you may go ahead.
El licenciado puede proceder.
Alex Lubianski for plaintiff.
Y estoy aquí defendiendo al demandado.
Could you two gentlemen unmute and state your name?
Si ustedes dos caballeros se pueden quitar el botón de silencio, por favor, y declarar sus nombres.
José Luis Cerda Aguiñaga.
José Cerda Contreras.
José Luis Contreras.
Sí.
Yes.
This is a termination of tenancy case, counsel?
Yes, Your Honor.
Esto es para terminar un alquiler, sí, su señoría.
Sí.
Yes.
Okay, what I'm going to suggest is that you contact legal services to try to obtain an attorney before we proceed any further. And maybe counsel needs to check with their client to see about the conversation that he just referenced.
Mi consejo es que usted se comunique con servicios legales y trate de obtener para que pueda discutir este asunto más a fondo. Y también pues al licenciado aquí que hable con su cliente acerca de esta conversación que se acaba de hacer referencia.
Ya está bien.
So I will adjourn this out 1 week to May 31st, 2024 at 12 p.m.
Entonces vamos a levantar la sesión y vamos a reagendarla hasta el 31 de mayo del 2024 a las 12 del mediodía.
Sí, está bien.
Yes, that's fine.
Your Honor, is that on Zoom or in person?
Señor, su señoría, ¿esto va a ser en persona o a través de Zoom?
At this point, we can do it by Zoom, if that's what you prefer.
A este punto lo podemos hacer por Zoom si eso es lo que usted prefiere. Gracias.
Sí, sí.
Yes.
All right. Thank you.